Hi everyone, welcome into Life and Law with Debora Diaz. I'm Barbara Marville Kelly. Thank you so much for joining us. My goodness, we're back again.
And I'm Debora Diaz.
We have a lot to cover today. I want to thank you for joining us. If you're new watching the show, just to let you know that Debora has just a little bit of experience, like over 22 years in family law, and what she's been doing is sharing a lot with the community, things that I never even thought of or never thought I would have to think about. You really bring onto the table things that we can learn to really kind of keep us out of trouble in a way. You know?
That's one of the goals of the show.
Exactly.
Share information and education.
Exactly. So we have covered from soup to nuts, from bullying to what not to do out there on social media, what's happening when you're going through a divorce, and the what, when, how, and
estate
where.
Issues.
Estate issues.
Probate.
Very, very good. So I'm going to turn the show over to you because you have like 25 things on what not to do when you're going through a divorce, and we're going to cover as much of that, but we do have a few questions that we're going to pick up from the last show, and so keep those questions coming. We'll get our phone-in number up on the screen, and we're going to get rolling here.
Okay, yes, and also our email, lifeandlawwithdebora@gmail.com. Email your questions.
That's right.
All right, one of the questions that we had left over from last week was, so I get it correctly, is it possible to enforce a non-compete? And the way the person phrased it was retroactively enforce a non-compete when they didn't have one in place. We ask a little.
You were asked that question?
Yes.
Wow.
Yeah, it was like this long drawn out.
Wow.
And so I'll start off with just a little education and say that non-compete agreements, if they are drafted correctly, are enforceable. In fact, we have a specific statute under Florida law 542.33, I think. I could be a little bit off on the numbers, but it's a specific statute that applies to non-compete agreements. And if they have a legitimate business interest and drafted correctly with certain geographical and employment limitation guidelines, they will be enforced. But they do have to be in writing. So this person was asking the question, if it was a verbal agreement, would it be enforceable? And that answer is going to be most likely not. It's not. This is because what you're doing is you're asking to enforce a contract that is likely to be enforced in the future, and it has to be in writing, because otherwise it's going to turn into a he said, or he said, she said disagreement as to what the contract was that you were trying to enforce.
On that note, can you just explain the definition of this contract?
Of a non-compete?
Of a non-compete.
A non-compete typically, and we see these a lot in between some doctors, even in law offices sometimes. Pest control is another one. Sales, those competitive businesses where you're hiring someone in, or you're bringing someone as an independent contractor, and you're sharing all your information.
Okay.
So you're sharing your data, you're sharing your pricing, you're sharing your customer lists, how you come up with your ideas, so some creativity, so a whole gamut of things. And you're sharing that information with the person, and a lot of times you're providing training. So you're investing in this person, so you're providing training. They get all of this information, and then 2 or 3 years down the road, they may leave and use all of that information against you by opening a business, same business down the street. So what a non-compete agreement will do will say, you're agreeing to keep all this information confidential for a period of time, anywhere from 6 months up to 2 years, okay, and courts have upheld that, okay. People keep saying, I get calls and say, oh, well, I can't work. Well, there's all kinds of disclosures that the person signing it realizes what they're signing. They realize that they will be able to get a job afterwards. And so they know that they're going to have this prohibition by signing this agreement.
Okay.
And usually it's prohibiting them from, for a period of time and from a geographical distance. All right, so it might say a pest control company in Pasco County might be wanting to prohibit, and maybe they just operate in West Pasco, just the West Pasco area, okay? So they might have that as their geographic. They might have specific cities, they might have specific zip codes as excluded and say you cannot open up or do any business here with customers that were customers when you worked at our business, kind of thing. So it's those kind of limitations. There have been agreements upheld that have been throughout the state of Florida. Sometimes there's a business out there that they can show that their whole geographical sales or their market is the state of Florida, and if it is viable, that upheld. They have been upheld.
Okay.
With that, but it has to be a reasonable limitation, both geographically. You can't say, if you're a pest control business, again, I'm just using that as an example, and maybe you've only ever operated in Pasco County, it would be unreasonable then, I think a good argument to say, oh, you can't open a pest control business in Hillsborough County. Okay, so it's those kind of limitations as far as geographic and time period. I mean, the courts aren't going to most likely enforce one for 5 years. Okay, what's been upheld is 2 years is considered reasonable. One of the things that I encourage everyone though to do is if they are thinking of either about drafting of this, don't do these cut and paste from the internet, okay? Really needs a fact-specific discussion with an attorney as far as if you're the employer, what it is you're trying to protect, to make sure that it's drafted correctly. If you're from the employee or potential employee that's going to sign one of these, you want to know what it is that you're going to sign. I've had many times on both sides where I'm sitting with a consultation with someone and they're very distraught because they didn't realize what they signed, or they didn't realize that what they thought they were going to protect in their business was not protected.
Exactly.
Okay, so you want it listed out, and there are some protections without having this. I mean, you cannot, trade secrets are protected. There's a statute in Florida where you can't give away, trade secrets and confidential information. But many times, this is a common thing in a lot of competitive businesses where your customer list is valuable.
Of
it's
course.
really valuable. Of course. So you can imagine that with doctors and the pest control sales. Those are the businesses where you see a lot of these agreements being used.
So basically, the right to work in Florida doesn't,
right to work,
that is totally separate, right?
Right to work only means that someone has a right to work at that employer if there's a union in place, and we have very few, unionized workplaces, without joining a union. That's the only thing, right to work. So I always say, and I'm saying that's a misnomer. It really doesn't mean right to work.
Right, exactly.
It really means, okay, you can work there and you don't have to join the union.
Okay.
Okay. So that's what right to work. And
Okay,
the other term that's out there is employment at will. And yes, Florida is an employment at will state. So without a contract for employment, meaning specifically a contract that says you start on June 1st, 2017, and your end date is June 1st, 2018, and it defines it, then that's a specific, okay? Many times, again, there's some miscommunication. People think because they got an offer letter, or maybe because they moved here from another state by an offer letter, and they get here and they take the job, and then 2 months later they're terminated, and they think they have an employment contract. They don't. An offer letter is not an employment contract that offers a job and says, I'm offering you a job, please move here, and other terms.
Right. Go to a lawyer. Go.
Exactly. In both sides of this, go and get some advice before it's signed and before it's drafted, because you want them drafted correctly. One of the things that happens in non-compete agreements is, again, you can't have selective enforcement. So I've seen many times where you have employers and they have non-compete agreements in place, but employee A leaves and B leaves and they don't do anything about it because they didn't view those employees as a threat. And then employee C leaves and they want to enforce their agreement against employee C. Well, one of the issues, the defense from the employee C side would be, is, well, you didn't enforce against A and B. Why are you going to enforce against me? Your agreement can't be that important to you, can't protect that much if you're not enforcing against the other employees.
That makes
And
sense.
so that's one things that, employers could get caught on as far as not, realizing that if you have non-compete agreements, they need to be enforced
Exactly.
across the board.
Exactly. Well, that's.
that is a quick
I'm glad I
question.
asked that question. But you know what? These are things that, the fine, minute details that so many people just assume that it's this way and it's that way, and so many people are really misguided
on
about
the
that.
non-competes, again, on the side of where employees, I've had it come in my office, and they've been terminated, too,
Yeah,
and that's
yeah.
usually what happens.
Yeah.
And then they're saying, well, how come, I can't work? You mean I can't do this? And the answer's going to be no, you can. And what happens is some of the remedies, if they've signed, the employer can prohibit them from working. They might have a job at a new place, their competitor. They can get an injunction against that employee from working at the new place. And they also will try and file suit against the new employer for using their former employee's knowledge. So it's a whole area to get advice on either side, if you're thinking about drafting them or if you're thinking about signing one.
Wow. That's a lot of information, and this is what we're all about
so
here with Life and Law with
and
Debora.
that took our first segment.
I know, right? We probably could stay on that, but
Okay,
when we
yes,
come back, we
good
have more to cover. So let's take a little housekeeping
Okay.
break, and we'll see you back after this.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Okay.
And we're back here with Life and Law with Debora Diaz. I'm Barbara Marville Kelly. I tell you, we really dug into some good information.
It was like a fast and furious 12 minutes.
I know, but you gave such great information on non-compete. I mean, and we could still be talking about it, and we will throughout Debora's shows. But we are going to pick up what we talked about in the beginning.
We were going to talk about
25 things on what not to. You mean there's only 25 things
There's
not to do?
There's a lot more, but I kind of
I
distilled it down to this point for 25 things that I view
really
as top
major
things.
ones.
Yeah, major things.
Let's hear
I'm sure
it.
there's a lot more. And it's funny because I always say, well, you don't think you have to counsel people on things not to do. But we do.
But you do. I bet you do. Yeah.
We do have to say this. So, and my disclaimer is that as we were just talking, it's not all inclusive, but you know, it's some highlights. One of the ones very important that I always view is if you have an ongoing case. Okay, and this really applies to all litigation. You know, I've termed it not to do during divorce or family law, but one of the first things is not to lie or hide things from your attorney.
Exactly.
Too many times, you know, there's not enough information, and I can't stress that, you know, your relationship with your attorney, it's attorney-client privilege. Unless there's going to be a crime committed, knows it, that's said, your attorney cannot breach that. Okay, the attorney, everything you say. So the attorney might not like it, is not going to make a judgment, but you need to share the information.
Sure.
No one wants to be blindsided on the day of a hearing or on the day of a trial of some information that was not shared, or that was an outright lie.
Right.
So one of the best things you can do for your case is to be honest and forthright with your attorney, and to share everything, and it means disclose any illegal drug, prescription drug, if there's alcohol abuse, make sure you're disclosing all your assets, and be honest about any negativity, domestic violence, adultery, or things that's going on in the relationship.
On that note, I assume that you have like an intake where you get all the questions that you require, just like what you said just now, and that's where
Yes, that's later on. We have a sheet that they fill out after we have. I mean, our initial intake is some basic information, but then we're an in-depth questionnaire if they retain my law firm.
Okay.
Okay?
Very good. Very good.
So that's number one. Number two, don't use illegal drugs.
Really?
Yes. And you know, we have to say this.
Yeah.
We have an extremely illegal and or abusing prescription drugs. Okay, we have an opioid, if I'm saying that correctly, epidemic.
Yes,
okay,
we do.
in Florida. I think
We
we're on a list.
We're
I mean,
up
we
there.
have a
Very
task force
high.
that was formed, and so we're on this list that we have a very, very pervasive prescription drug abuse problem.
Yes.
That needs to be disclosed. It affects it affects child custody. It's going to affect the case.
Exactly.
Okay, your attorney needs to know about that. All right.
And Debora, but what about these people that are taking a legal substance? It's legal, and so they're under that. They don't realize there's an epidemic. They don't realize what's going on here, how it is affecting. I mean, I personally know people that are
Look, I don't have to go too far. Look about in the news. We thought it was this, Tiger Woods. Okay, it was driving while impaired, okay, and everyone rushes to judgment, but apparently it was, you know, prescription drugs. He's had back surgery and other surgeries, so he's had. I'm not saying he's abusing, that's not it at all.
No, I know
but
that.
He's out there driving a vehicle that all over they tell you when you're taking medication, don't drive machinery, and
That's right.
you know,
That's
things,
right.
so.
And the poor guy, I mean, really.
Yeah.
You
I
know.
mean, and look at that picture that's forever, ever going to be on internet.
Oh, I know.
And never go away.
I know.
So we have, you know, this supposed, you know, role model in the news.
Sure.
And
Sure.
that's his picture. So no matter what, you know, for the years down the road, what happens, I mean, that picture, when anybody talks about Tiger Woods, that picture's going to come up.
It's gonna come up because that's the last thing that they heard,
kind of,
or
you know,
whatever.
a little bit off topic, but it's related to this.
It
that
is.
we have so many, this use of illegal drugs, and related to that is this abuses of prescription drugs. People, you know, using this and doctor shopping, and it's important, as I said, because it can be used against the person, and the time sharing, because time sharing, one of the factors is best interest of we're looking at the best interest of the child, and a parent's behavior is part of that. Their moral, illegal, or drug abuse issues or alcohol abuse can become part of that analysis that the court will use.
And that's the part of legal prescription drugs. It still impairs so much.
Yes.
So much that can affect children.
Definitely.
And grandchildren.
Definitely.
So yeah, I'm glad that you're bringing this up. It's pretty powerful stuff.
Excuse me. Don't discuss the case with your children. Okay, no matter what. I know it's hard. People want to get the children to take sides. That's a no-no. The children don't need to know. They're going to know that something's going on. But they don't need to know all the details. They don't need to know mommy and daddy went to court today, mommy hates your daddy's lawyer, daddy hates your mommy's lawyer, your daddy won't pay me child support, or your mommy won't pay me child support. The children don't need that.
No,
they don't need that. And that will be held against. The parents are talking about it. They're going to be one of the factors that come out in the case regarding time sharing. The parents, they just cannot be talking about the case to the children.
Now, if they do, just in general questioning, if they do, and that's found out later on, can that affect them with their time sharing with the child?
It could.
Oh,
yes.
okay.
If there's
I'm glad I asked that then.
If there's a pattern out there and we go back into court, it could be.
Okay.
Yeah, could be. And they're going to be admonished. And that also goes, I'll take it one step further, it also goes that means that no one else around that's related, the grandparents, your sisters and your brothers to the people that are getting a divorce or in some other family law issue, should not be talking about the cases. I mean, I've had cases where the children are time sharing and the grandparents have said something really negative about the other spouse, really bad. And, of course, that's going to be effective, and that can be that, that they're not going to be allowed to go over and time share. And the parent would have a legitimate reason to say, they're not going over there. They're not going to visit their grandparents, or you're not allowed to have them over there.
Right.
Whoever's talking. So this goes, so not only you should not be talking about the case, all of your whole circle of acquaintances and friends should not be talking about the case in front of the children.
And that's such human nature, so I'm really glad that you're stressing this on what not to do.
People want to talk, but you shouldn't.
Because it can affect the whole thing later on.
It can come up as an issue in the time sharing.
Okay.
But even more importantly, besides that, it's bad for the children.
Of course it is.
That's the thing. It's bad for the children. Right? So it's negative.
Yeah.
You don't want that. Okay. And I go to this and I say, okay, all right, don't post your divorce drama, family law drama, child custody issue on social media. That includes everything: Facebook, Instagram, LinkedIn. I don't know if people use that too much for that kind of stuff, but Snapchat, Twitter, whatever else is out there and new that I'm forgetting to mention this time, don't post it. Don't post. I went to court today and my lawyer really did this to the other side, or I went to court today and I won, or, and with specifics and talking about your case and talking about what's going on in your case and talking about maybe a new significant other. All of that does not belong on social media.
And can that also be used down the road?
Absolutely, yes. Okay?
Ouch.
Social media evidence can be, if it's authenticated, can be used. And we have used it. I have used it. Text message, and I'm going to broaden this and say text messages, posts on social media, if authenticated, can be admissible in court to prove one issue or another.
There you go.
So it's not, don't do it.
You're hearing it right here.
Yes, and this applies with, other cases too. I'm concentrating on divorce and family and other family law cases, but this is in other cases too. Your drama should not be posted on social media.
No.
Keep that to yourself.
And it just heats things up more, adds more fuel to the fire. I mean, there's enough drama in this crazy
Everything
world.
that's out there. People don't think about the impact of social media. They think, you share one picture and you post a picture or you say something. Even if you're just saying it to their friends, when you look at your privacy settings, all their friends, they can see it.
They see it too?
They can see it.
I know.
It has a all you have to do, for an example, just to show the extent of social media, I was on a cruise over in March, and I happened to take some pictures, the only pictures available of a guy proposing to his fiancée in the casino time, okay? And afterwards, they gave me their email address so I could send them all the pictures I had taken, but we were one letter off or something, and I could not get them to. And I was sad because I wanted to, because they were the only pictures.
Aww.
I posted on social media, went on a cruise, posted one picture of them, said, met this couple, they got engaged on the first night of the cruise, I want to get their pictures to them, okay? Please, anybody knows these, find it, okay? Within one day, 24 hours, okay?
See?
We were connected.
How
we were
about
connected
that?
and said, I think I know them. And in fact, we were so that it had been shared so often, and they were from Georgia, that a radio station picked up the information, picked up the pictures, and called them and told them about it on the air,
Now,
too.
see,
That's the reach of social media.
Yeah, it really
Okay?
it is, and you just never
These
know.
people, they were not my friends on Facebook.
Yeah.
I knew nothing. I knew their names, and I didn't even know they were from Georgia. I just knew that they had, that this was their pictures, and people identified them.
That's a good
So
story.
if you it was
That's
really
a good story.
I love it. We're still in contact. We're friends, so it really is a good story. But but yes, it's just to show the impact of social
It's powerful,
media.
and once
Yeah.
it's there, it's there.
It's there.
Try to get it off, right?
Right.
Wow, it's exciting. It's exciting getting all this information from you, Debora. We're going to take a break in just a few seconds,
Okay.
and when we come back, we're going to be talking about more. We've only covered a couple of things
We've
here,
only coupled a couple
and that's
of them.
okay.
That's why I knew this was going to be a 2-show process here on these 25 things. So we've gotten through 3 so far.
I know.
But
Well,
we'll get through
just
more.
think
We
of
can
all the
speed 'em up.
people that you can help
Yeah.
out there on
I
what
hope
not
so.
to do. Exactly.
We hope
Going through
so.
the divorce. So we're going to take that break, and when we come back, we'll have more for you right here with Life and Law with Debora.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Hi everyone, welcome back into Life and Law with Debora Diaz. It's great to get the information out there to people. So, okay, we've covered a couple of things on the 25 things, which we know that there's probably more. We've covered a few. So, what's next?
Well, the takeaway from the last segment, don't post online because well-respected adults can damage their credibility and the case. So, don't post online.
Who knew? Did you know that? Here you go.
Okay. Don't bring your new significant other around the children, if at all possible, until the divorce is final. I know it's hard, people have human emotions, and sometimes the case goes on, but at least, try to delay it as long as possible.
Yeah.
And this is important because I say to my clients, you want to get resolution. If you are the person, and I'm representing, that wants the divorce and the other person didn't so much, okay? And you're bringing around a new person already into the mix, that inflames emotions.
It absolutely, and it's hurtful to the children.
It's hurtful to
They're
the children.
already hurt.
But it inflames the emotions. You think you're wanting to get an agreement. How likely is it if someone's pissed off at you, excuse my French, that they are going to agree to something?
That's right.
So it really is as much, be discreet.
Yes.
I guess
Yes.
is the takeaway.
Bottom line.
And this, be discreet with that as much as possible.
Good advice.
Okay. Early on in the case, as you're starting, and this is specifically applies to a divorce case, is to make an inventory of the household items. Look at this, because things, might start disappearing or not if both parties are in the house. You want to know, have a sense of what it is. In this day and age, you can take your cell phone and video now,
Sure.
but if you don't want to do that, you can write it down. But take an inventory, and I'm talking about the major things. I'm not talking about this. Know how, what do you have in computers? What do you have in, collections and your household furnishings? So know what you have, your inventory, because that's going to be part of the discussions. The value, and then what does each party going to want to take away?
Right.
Remember, when we're talking equitable distribution, each party is entitled to half, as close as possible.
There you
so
go.
you want to know what you have.
So that's more or less proof
This is
to show what you've
you
got.
have, and we want to know if things are, especially with pictures, and knowing if things have been removed or destroyed, too. So that's why you want to be listing, taking some kind of inventory, whatever it is that you feel comfortable, that they feel comfortable in doing it.
Makes sense.
Okay, we're kind of as an offshoot or related to this is I tell my clients to keep a divorce calendar or a diary of events, and this is easy. You can go either go to the dollar store and you can pick up a calendar with the nice big blocks of each date, that has room to write on is what I'm talking about, or download and print off one. And this is where you're keeping, what's going on. If there's issues about time sharing, you can be writing down, husband wouldn't let me pick up the children today, or wife was nasty today and said this, and this in front of the children. And you're keeping a kind of a record. This is not a record to be flaunting to the other side. This is a record for your use and for you to share with your attorney. It's the diary of events, because many times if we're particularly in a time sharing case and the other spouse hasn't been cooperative, maybe is always late for a pickup or having an excuse. So if we're going to have a trial, and that trial's not going to be for a year down the road, what better to refresh the memory as to what happened and what's been the ongoing pattern of someone than to say, you kept a calendar of events, and you know, how many times did your spouse do this, and how many times did this occur, and you have it. And how do you know that? Because I kept a ongoing calendar or diary of events as it was happening.
Right, right.
And so the information is right there and is going to be credible and is going to be given weight.
And that can be used.
And it can be used.
Oh, that's
yes, it can be.
It can be used. So diary, journal. If you do any kind of journaling, I mean, just include that in there every single day. That just makes so much sense.
Okay, this is preparing how you want to, you know, prepare for your case. Don't bring, and this is, you don't think I would need to say this, but I do. Don't bring your new boyfriend or girlfriend to mediation or to court.
Do they?
Yes, sometimes. Not mine. I mean, I'm really telling them not to. They're not going to be allowed. Okay, they're not going to be allowed in the hearing room. They're not going to be allowed in the mediation room. And think about this, again, goes back to trying to get an agreement. You're showing up to mediation, which is the process where you're trying to get an agreement,
right?
Okay, and you walk in with your person, your other person, to be there and sitting there on the outside. And so then the parties are into mediation, and what does he think the other party's thinking about? Oh, he has his girlfriend out there, or she has her boyfriend out there,
inflaming
waiting,
the whole
inflaming
thing
the thing. How conducive is that to getting an agreement?
It doesn't make any sense.
So it's like it's just not appropriate. Okay, so that's one of the, you know, that I am
kind of surprised that you have to say that, but you do.
You do, and so it says it's not going to help settle your case to do that.
Okay.
Okay. Okay. Don't leave nasty voicemail messages or text messages to your spouse or the other party if it's a paternity case, okay? And this is, and it happens, and there's no expectation of privacy. If you leave a message, you've left it. You know you're being recorded. It can be admissible, okay? That can be admissible in court. So, and I'll tell you, you know, as related to this, I had a, you know, a client that said, is there something I can do? My wife is doing this, this, and this, and leaving these nasty messages, and I, you know, I looked at him, and it could be the wife or the husband, I'm just changing the this, but whoever it was, let's say I represent the husband, and saying, okay, well, let me, you know, so left me out. So I said, well, send me everything, let me look at it, and this, and you can download and see the text messages, okay? So I'm looking at all the text messages, and I'm seeing what the other side wrote, and then I'm seeing what my client responded. And I said, not going to happen here, that I'm going to want to use this.
Right.
Because my client's response was just as bad as what his spouse or her spouse had
And you
written.
can't take that out.
You can't
It's
take
there.
that out. If I'm trying to say, oh yeah, my client received, you know, was left all of these bad messages, and then the other side's going to say, and look what your client did.
Right.
Okay, they were just as bad.
Yeah.
So on both sides, don't be leaving messages that are nasty. Keep it simple. Keep it simple. Keep the drama out of it. Keep your tone nice. Especially when we're talking about the time sharing, that can all be into play, into play in court.
And I just think tempers flare and everything, and they're not.
They do.
They're not
They
thinking
want to.
about the wee ones, how it's going to affect them. They're so into, like you say, the drama.
Yeah. I mean, they were the ones. This one, you know, the other side was leaving, you know, really bad words, really bad words in the text messages. But my client wasn't so nice either. So that was all going to come out, and you know, the court's going to would see this and say, "What? Neither one of these parents should have these children."
Oh,
okay?
I can only imagine.
Yeah. So, and how I say it as a advice is think about everything you write down and everything that you leave, and would you want it to be out in a court of law?
And would you want your children
would you want your children to hear that? I mean, sometimes they're as nasty as calling each other really bad names back and forth. You know, things. So exactly, do you want your children hearing that about either parent?
Exactly.
Okay. But on the other hand, don't fail to keep them. You know, if you haven't responded and you're getting these bad messages, to keep them, take screenshots. Your text messages are savable. They can be saved. You can take screenshots and you can have them, and if they're authenticated, they can be admissible. So if someone is acting like that and the other side is sending you that kind of stuff, no, you don't have to respond, But you want to keep all of that because it
Absolutely.
may be able to, it may be used and admissible.
Right, so keep everything.
So keep everything. Exactly. Excuse me. Don't dispose of assets. And
Don't dispose of what,
particularly
dear?
assets.
Oh.
And don't dispose of assets to be vindictive. It's not going to look good. As soon as a case is filed, and we're talking about a divorce case, a temporary order is issued, comes out, and and basically some of the basics in it is, don't be buying, selling, moving around assets, and if you do, it's better be shown that it's reasonable and necessary.
Okay.
Okay. So don't get rid of your husband's favorite gun collection because you're going through those kind of things are going to be viewed as vindictive and mean, and it's not going to look good in court. So on both sides is again going back to knowing the assets you have, but don't be vindictive about getting rid of anything.
Okay.
Okay. Okay. Don't fail to read all of the orders entered in your case. When my clients get every single thing, a communication that comes out of my office, and all orders, they're copied in, and so the clients need to read those. Keep them and read them. Keep a file and have everything, so you know what's going on in your case, and that's should be something that they're doing.
Can you define for people that have never been through that, like the orders such as?
There might be, say there's a temporary order entered regarding child support. So keep that, know what it is. You have ordered to pay child support and you have to pay so much every 2 weeks or receive it. Know what it is. Know what it is. So that's the order, and there's temporary, in the case there's the temporary orders that could happen when the case is pending. There may have been a temporary order entered, or there may be a temporary agreement, so know what that says.
Perfect.
Okay?
Perfect. We're taking a break
Okay.
again already. We'll be right back.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Welcome back in, everyone, to Life and Law with Debora Diaz. We're covering a lot of territory today, and we've saved some of the best for last, which is in our last segment, we're going to be talking about little odds and ends, a little bit of everything.
Yeah.
And I know you wanted to cover another question.
We're just going to go through one more of my top 25 things not to do, and then leave the balance for next week. So you have to tune in to hear the rest of them.
That's right.
But okay, number 13. Do not fail to keep your attorney informed about what's going on.
Oh, that might be a good thing to do.
Now, this means your address, your email, and what's going on with you. If you lose a job, if you get a reduction in income, all of the things that are happening, even though you think it's not important, it may be, so you need to keep your attorney informed on what's going on.
Yeah, especially if you lose a job and if you've got children.
Exactly.
Oh, yikes.
You need to, that's all important stuff. Again, even though you might not think it's important, it's important. And do not fail to respond to your attorney. Okay, that is either by telephone or email. If your attorney is calling you or emailing you, you need to respond. Okay, you need to respond at a minimum that you receive the whatever it is that's communicated, and then if it needs more, to say I'll get back to you when I can. Okay,
Yes.
There's nothing when you're trying to constantly get communication out there and you're not having a response from your client. That's not good either.
That's right, and it doesn't necessarily mean it's going to be bad news. It could be.
It's news. We have to. Sometimes cases are moving really quickly, and we might have a settlement offer coming in, or something that we need to talk about.
Sure.
So you want to get a response.
So you could be missing out on something really to your benefit.
Exactly. So keep
good
your
advice.
Keep your attorney informed.
Yes.
Of what's going on. Okay. Okay. We're going to go now to our little kind of what I'm calling odds and ends section.
I love that. That's a great idea.
Different things that are going on that I wanted to share with the community and stuff. So first of all, if you don't know it or not, June 1st is the start of hurricane season.
That's right.
Okay.
Oh, joy.
But in Florida, we have a Florida tax holiday.
That's right.
So if you don't know that,
a lot of people don't.
And that's for this weekend. Okay, and it's a sales tax holiday. And it offers the tax cut on storm supplies up to a certain price, including portable self-powered lights under $20, qualifying batteries under $30, and generators less than $750, and some first aid kits and things like that. So you can go do an internet search or this, but it's a good time to go out and stock up on some of those hurricane supplies, because we go for all the way till November.
I know. We've been pretty lucky lately.
We have.
You just never know.
Get some that this is going to be an active season. So this is part of being prepared. What we'd call about life, being prepared.
Yes, being
so if you
prepared.
can, whatever you can, get ready for hurricane season.
That's right, because you never know when it's going to hit and whether or not you have a roof leak. So
exactly.
I'm glad I got mine fixed. But that's really some good advice during the hurricane season down here.
I like to share that. We have. Then I wanted to share about, if you don't know this, Pasco County schools are serving breakfast and lunch this summer, and they're having buses go out into the community. Pick up. This starts June 5th. So if you have one or you know of a school-aged child that's in need of breakfast or lunch, You can text FOOD, F-O-O-D, to 877-877, and I'll repeat that again. You can text FOOD to 877-877 and receive a message back with the location that's closest to where you are and where they can go and get free summer meals.
And that's Pasco County.
And that's just for Pasco County. So this is a really good service out there. And
Yeah, it is.
you know, something that's available, because some kids rely on free breakfast and lunch as their only meals per day. So this is a good thing being offered by the community. So if you need to, you know, take advantage of it.
Absolutely, absolutely.
Okay, and I've posted some information on my Facebook
I
page
saw that.
too. The same,
I saw that.
same thing.
Yeah.
So if you've missed that, you can go and do that. Want to talk about one of the organizations that's near and that I really that's doing some good things in the community. It's called Marjorie's Hope, and it's giving hope and making a difference to children and women in the community. Okay, giving hope to children. One of their big things is the back to school backpacks. All right, and they're making sure that every child has the basics when they start up with school, and it's not to start. I know school just ended last week.
I know, but it'll be here
we're
before
weeks
you
there.
know it.
Yes, and what this organization does is stuff backpacks, gets all the supplies and some hygiene supplies, backpacks, and gets them and has a site where the schools can come and pick them up.
That's
and
awesome.
Pick up the backpacks.
That's awesome.
They also have a clothing closet for school-age children. That's part of their back-to-school program. So this is a program that's making a difference in the community.
Oh, no
so
doubt.
So if it's something that you feel inclined to do, you can support it. But I'll show you Marjorie's Hope Every Day is a Gift. You can go online and research about the organization. And as part of that, they're having a fundraiser on Friday, which is tomorrow.
Oh, that's tomorrow, yeah.
Yeah. 7 o'clock at the Gulfview Event Center, and what they're having is called a quarter auction. And if you've never been to one of those, they're really fun. You bring some quarters, and the items are up, showed, displayed, and everybody, if you want to bid on that item, you put your quarter in and you hold up your paddle with your assigned number, and so your number's drawn out like a bingo ball, whatever.
That's cool.
So the number.
That's
so
fun.
everybody has an even chance to win, and if you want to bid on, have 2 or 3 different numbers, you can buy different paddles. But tickets are $20 per person. Credit cards are accepted. Teachers with a school ID will be entered in a raffle for a chance to win a teacher gift basket. If you want more information about this event, you can contact Debbie Shakowski at 727-776-5458. Again, Marjorie's Hope Every Day is a Gift if you want to find out more about that.
That's wonderful.
So this is a really good project that's doing a good organization that's doing a lot of good.
And I have to really give some credit to Debora as well, because Debora is very, very active in the community. In fact, we even did our own fundraiser with the Keep It Local, and you donated all those beautiful backpacks. So thank you for all that.
Children are our future.
They are.
These are causes that are near and dear to me.
Yes.
The children, making sure they're clothed, making sure they're fed, and we want, education is important, but in order to learn, they need to be fed. Okay, you can't concentrate when you're hungry.
That's right.
I'm not making light of this. This is true,
No,
and this
it
is
very true.
I've seen this firsthand. What a difference it can make as far as children.
So that's good.
We wanted to
Marjorie's
Hope.
I love that.
Okay, so that's that's what I wanted to talk about. That. I wanted to share this issue, so this is kind of a beware issue. You may or may not know this, but when you close on a house, you buy a house, you get your deed, okay? You get your deed to your property.
Oh, I know where you're going with this
all
one.
right?
Yeah.
So eventually, you close at a title company, and your title company, it's recorded, and then you get it in the mail, okay? There's organizations out there that send out these, it's called, and I want to show it so that you can, I'm not sure if you can, it looks so official, so you can see where people are going to be scammed by this, okay? And this one came from this company, called First Documents. Doesn't that sound really this? And they said, you know, and they said, get a copy of your deed, and it goes on through why you need a copy of your current grant deed and property assessment profile. And I'm reading this, and it has my property, you know, the property address on here and the recording date and everything, and it wants me, and it wanted me, because I had purchased a house last year, and it wanted me to send them $83
For a copy of...
to get a copy of my own deed that I already had a copy of. Okay, this is how, and people,
Red flag.
and you can see though, and I'm reading this.
But you're an attorney.
And I took a second, and I'm looking at this and saying, wow, what's going on here?
Yeah.
Yeah, so this is just one of those things to be aware. Read things carefully, not get caught up into this scam.
That's
They're
right.
making money that's really, and it's not, are they doing anything, you know, illegal? Probably not. You know, but they're preying on you. You can
Yeah,
see where
questionable.
sometimes people, you know, there's, oh yeah, I got to get it. I got to get my copy.
Yeah, yeah.
Okay, so
Yeah.
that's not, yeah, so just be cautious. Read things. When you get these kind of things in the mail to read about that.
And that's really raising the awareness.
Yes, yes. And the other thing that I wanted to talk about is right now pending before ready for the governor to sign is what we call his presumptive time sharing bill that would add presumptive time sharing in paternity cases. Okay, and why I think it's a bad bill and why the family law section of the Florida Bar thinks it's a bad bill is because it's going to say that when a paternity case is usually just, they're just getting child support set down, okay? And so without either of these sides knowing the law, an administrative law judge is going to have the parties enter this into this presumptive, meaning that it should be 50-50 time-sharing agreement without any weighing of the best interest factors that we do now under the law. Okay, meaning there's not going to be, you know, the moral fitness, the activity, the, you know, how the parents have been communicating, a whole list of factors that we don't have time to go into. So I'm encouraging everyone to call call the governor's office, email the governor's office, and say, you know, in my opinion, that this is a bad bill. It should not be. We don't need this. It's bad for the children. It's bad for children of our state. There's a lot of domestic violence issues, drug issues that affect in the best factors that need to be considered before we're putting a time-sharing in place, a time-sharing plan in place.
Wow.
So that's my reading. If you're so
now, see,
inclined.
I didn't know about that.
It's a Senate bill, and I want to make sure I get there. It's Senate Bill 590. So,
Senate Bill 590.
Yes, so you can contact Governor Scott at 850-488-7146. And I encourage people out there, this is bad for children.
Well, thank
So
you.
I'm going to say
that was
say
the best.
that. So that's what I'm going to say.
We did
in
save
my,
some
in
of the
my
best for
odds and
last.
ends section.
There you go. And you'll want to tune into the show every week, Thursdays at 4:30. And also, if you'd like to be a sponsor on the show, if you have a business, please get a hold of Debora or myself. We'll be happy to get you on. So thanks for joining us today. We'll see you next time, same time, same place. Thank you, Debora.
Welcome.
Good show.
Good show.